Good morning, everyone. Good afternoon. My name's Rob Whittall. I think you most will know who I am, and it gives me great pleasure to invite you to our sort of first Meet the Expert webinar. So welcome and thanks for joining us today. The aim of these programs is to try and do them on a quarterly basis, and we're going to pick topics which we believe are going to be appropriate for our client base of various things which I think are significantly different from a UK and a US tax perspective, to try and be of a lot of business use to everybody on the call. Just a few housekeeping points to start with is, first of all, would everybody please make sure their microphones on their computers are muted, or if they're calling in by phone, that you're on mute for phone. And if you have any questions as we go through, there is on the right hand side of the screen, there should be an area that says questions, that you can post your question there and send it to us, with the idea after the presentations that we will go through some of the questions, and to the extent that we aren't able to cover all the questions, John and or Ben have said that they will get back to those questions afterwards, so all the questions will be answered. So without further ado, I'd like to introduce our two speakers for today. John Yormick, who I've known for several years, is going to be talking about mitigating and managing US customs regulations and importing issues coming to the US. And Ben Farber, who is a partner at Phillips Lytle, will be talking about Officer and Director Liability, and also talking about when you should be registering to do business in a state that you're doing business. So John will talk for about 20 minutes, Ben will talk for about 20 minutes, and then the idea is having 15 minutes at the end to answer the questions. So it gives me great pleasure to introduce John Yormick, who will start the presentation today.
Thank you very much, Rob, and thanks to Dyke Yaxley for asking us to put on today's Meet the Expert inaugural presentation. Happy to be here. Thank you all for your interest in these issues. What I'll do is I'll go through excuse me, some of the basics of U.S. customs regulations and laws that many of you may already be familiar with, others less so. But we'll try and start with a baseline, and then certainly towards the end we'll get into more of the details on where the potential risks are, not only to companies that import into the U.S., but also for the individuals that are involved with the importing practices of the companies. And then I'll turn it over to Ben, who will speak to the corporate side of things. My practice is focused on import-export issues, mainly with U.S. customs regulations, as well as export control laws, and some Foreign Corrupt Practices and UK Bribery Act compliance, and plenty of cross-border contracts where I try to build in compliance provisions to help protect and minimize risk to our clients. So very briefly, nothing that Ben and I are going to say here today is specific legal advice. We're sharing information and providing general information at that. Very quickly about Phillips Lytle. The firm is based in Buffalo, New York, and has been around for a good long time. It's a regional firm. We have offices throughout New York State. My colleague Ben Farber joins us from Albany, New York, state capital. And we also have offices in Washington, D.C., as well as in Kitchener-Waterloo, Ontario, tech hub there. The firm, like many mid-sized firms in the U.S. and the U.K., represent a variety of business clients, from entrepreneurs and small and mid-sized companies to middle market leaders in their industries and sectors, as well as Fortune 1000s. We have nearly 200 lawyers covering a broad range of practices, some of which might be relevant to many of the companies there that we've listed. And the firm is also a member of Law Exchange International network of independent law firms throughout the world, and we work together on various matters. So very briefly, I'm going to provide a short overview of what I see as some of the U.S. and more broadly North America, NAFTA being the North America Free Trade Agreement, and the opportunities that these markets might present for UK-based companies. Again, an overview of U.S. customs laws and regulations, compliance with them, and potential liability issues. And I realized late the other day as I finished up my slides that I used CBP throughout the slides, and I had not yet defined it, so I put it right up front here. So when I refer to CBP, that's U.S. Customs and Border Protection, which handles customs matters here in the States. There's certainly a significant amount of foreign direct investment from UK companies here in the U.S., and as I understand it from Rob, many of you participating already have made that direct investment here in the U.S., and others may be considering doing so. Excuse me. I apologize. I seem to have a bit of a tickle in my throat today. Access to the U.S. also means access to the Canadian and Mexican markets. And Mexico in particular is a growing economy and doing quite well. The U.S. seems to be holding its own despite all of the economic woes around the world. Canada, being a commodity-based economy, has really suffered due to oil as well as other commodity price losses recently. However, it continues to be a market that U.S. companies look to and access. With the dollar exchange to the Canadian dollar exchange rate somewhere about 30% now, it does make it more difficult to sell your U.S. or for that matter UK origin goods and services to the Canadian market. However, my view is more of a long-term view, so that if you're already operating in the U.S., you really need to consider Canada as well as Mexico. And a quick point on non-resident importers. UK companies can import into the U.S. without having a U.S. entity. If that is an option for companies to consider, they're not sure if U.S. market entry and a physical location is needed, I would suggest that you may want to consider non-resident importer status, whereby the UK company is the actual importer into the U.S. It's relatively easy to set up, and it's certainly for your U.S. customers, you take on the import compliance and the logistics challenges as well as details, and they can appreciate that. So it might be a good strategy for new-to-market companies in particular. Really, the basis of U.S. customs law goes back to 1993 and part of NAFTA, and that's the Customs Modernization Act, or the MOD Act as it's known. And that introduced two key concepts: informed compliance and shared responsibility. But importantly, for purposes of our presentation here today, it created a duty on importers as well as those dealing with the importers of exercising reasonable care. Now, of course, our U.S. Congress did not do anyone any favors in the Mod Act. They did not define reasonable care, but we'll go through what is expected and what companies should be doing as importers to meet that duty. You see there in the first bullet, never heard of it. That's a direct quote from a new client of mine in Chicago, who I will go visit next week, and we'll have a sit down with U.S. Customs regarding an investigation. This company has been importing for a good 15 to 20 years, and saying the familiar refrain of, well, we hire a customs broker, they should know all that. As I'll explain as we go through, that is not going to be a defense. It does not mitigate your risk in any significant way most often if there is a customs penalty. So having never heard of it, of the Mod Act, that is not a good sign for this company. And hopefully it's something that I'm going to help you to understand and avoid. Informed compliance really means Customs using technology, mainly the internet and its website, to put up all sorts of information, including these informed compliance publications. U.S. Customs issues rulings on a daily basis, and those rulings are now accessible right on the Customs website, the cbp.gov website. So the idea of informed compliance is that U.S. Customs provides all of this information, guidance. You can access these rulings as well as the tariff schedule, of course. And because it's out there, it's freely accessible. Importers into the U.S. are expected to be familiar with it, read these documents, understand them in order to meet their reasonable care obligation. You see there that I've provided the link to the reasonable care checklist. Again, that would be a starting point for many companies, or perhaps a refresher for others. The concept of shared responsibility really, I think, focuses on this particular statute, 1484, which governs the entry of merchandise into the U.S. And you'll see here that the importer of record must exercise reasonable care. Now, that can be your U.S.-based customers. It can be your U.S.-based subsidiary or branch office, and it can also be, if you're a non-resident importer, your UK-based company can all be an importer of record. And you have to exercise reasonable care in these very important areas. And really, it's all about providing correct and accurate information to CBP in order to make the entry, classify the goods correctly. That in turn, of course, tells us what the proper duty rate is and the value. How much, what the percentage of duty may be, and then the value, of course, will help to calculate the amount of duty based on that duty rate and the value of the imported goods. The shared responsibility is that the importer has to do all those things, and CBP gets to determine the final classification and the value of the merchandise. So again, here are some of those entry responsibilities. I indicated that first bullet. I was asked by a Detroit client last week about helping advise it on some supposed chemical certificates that would be needed. Its goods were described on the Chinese supplied commercial invoice as resin. In fact, it was not resin. Its customs broker believe that it was importing actual resin, and that was going to trigger an additional compliance certificate. That, in fact, was not the case. You'll see some of the others there, which I'm sure will look familiar, including marking. All goods imported into the U.S., or virtually all goods, subject to very few exceptions, have to be marked with the country of origin. So made in UK for UK origin goods is sufficient. If it's made in China, happens to be transshipped through the UK, then those goods will remain made in China. So it's important to know the marking regulations as well as the country of origin for those purposes. Here in the U.S., we have several anti-dumping and countervailing duty orders, and it's not only against goods being imported from China or Vietnam as non-market economies, but several other market economies as well. And you have to be familiar with whether or not your goods may be subject to these orders and the very high duties that often are associated with them. Reasonable care. This is the duty that all importers of record, again, must exercise. And you'll see that it's stated as no person. And no person meaning that no person should fail to exercise reasonable care. No person can make false statements, incorrect statements when entering goods, and that relates to classification, description, value, and all of the other information that CBP requires. Going back to my example of I haven't heard of this, and that's what we hire the brokers for. Well, this responsibility, this duty cannot be delegated away, and likewise the liability for a violation of the duty of reasonable care is not somehow going to be delegated away to a customs broker. And the customs brokers will have terms and conditions of service, the proverbial fine print often on the back of the power of attorney that you are required to sign, appointing them as the customs broker. And usually there's a limitation of liability, so that if they do err in submitting documents on your behalf to CBP, that limitation of liability is often as low and quite often as low as $50 per entry. So you need to carefully look at those terms and conditions so that you can understand where your risk and liability versus the customs brokers may lie. Again, the customs rulings are on the website. The system is known as CROSS. I'm on there on pretty much a daily basis, and companies can request rulings generally on these four main categories. So if you're unsure, or if your customs broker is unsure, very often a request to customs is submitted for a ruling. Now those rulings are binding, so if you disagree with it, you're still going to be stuck with it unless it's appealed and reversed by customs, which only happens, as you might imagine, in rare instances. Valuation is a very tricky issue at times. It would seem to be simple, but there are additions to the price that's paid or that's payable, which must be included in order to properly value the goods. I've indicated there a little bit of a description on assists. That's fertile ground for customs auditors and inspectors to look at this value issue. So you must include certain costs, such as tooling and dies, molds that might be used overseas that are reimbursed costs from the company that's importing or from a third party to the exporter in a foreign country. And when those goods arrive here in the U.S., the costs associated with those tools, dies, those production items must be accounted for in the value. Otherwise, the value is incorrect. You may be facing a customs penalty. Some of the key documents that Customs puts out on its website would be the informed compliance publications. There are dozens of these. Here's a quick list of some of them. Record keeping is important. Generally, you're going to need to keep records for at least 5 years, and that could be a bit of a longer period for NAFTA transactions involving Canada and Mexico, where the timelines are extended out to as long as 7 years beyond what the U.S. requires, which is 5 years. So again, here's other ways that companies, importers can exercise reasonable care. You need to be reviewing your import documents carefully to make sure that they are accurate. This would be kind of a self-audit or review. Post-entry, you want to make sure that your payment records are lined up with the commercial invoices that are received. ITRAC is a Freedom of Information Act request that companies can submit to CBP, and will provide all of the entry information, and that can be a good control tool for your self-audit or self-review. Consulting with trade advisors, customs brokers, attorneys, accountants can also help demonstrate to CBP that an importer has exercised reasonable care. I've mentioned rulings, notices of action. Those are essentially directives, formal directives issued in writing by U.S. Customs Border Protection, and they must be followed. If you're not following those directives, you're certainly going to be liable for a penalty in most instances. There's also post-entry adjustments. Those are corrections. There are protests to address disputes. There's prior disclosure in case you do find errors and potential violations. It's always a good idea to self-report those, and then having a written compliance program for your importing practices is always recommended. This is a court definition. Leave it to a lawyer to provide you with a legal definition. This is from a case of some years ago now, but it gives you a sense of what a negligence violation is, and that's simply a lack of reasonable care. Intent is not required. So virtually any error in providing information to Customs can create a negligence level penalty. You'll see that the maximum penalty amounts increase with the level of culpability. Very quickly, if you begin to receive requests for information from CBP, this could be a prelude to an eventual penalty case. This is where Customs is checking for information and is potentially starting a formal investigation. There is due process. If there is a penalty notice issued, you have opportunities to respond to it. And ultimately, if a penalty is issued, there is an offer in compromise that can help to resolve those penalty cases. Quickly, there are some additional penalties that can be assessed, and these again are penalties that can be assessed against both companies as well as individuals. There is successor liability. So if you're looking at target companies for an acquisition, you need to be mindful of that as part of the due diligence process. And then the personal liability is there as well, as I've mentioned. And we'll skip to Trek Leather. This is a Court of Appeals case here in the U.S., and it really was bad set of facts making bad law. Here, there was an individual who was a 40% shareholder in a company, and he was held personally liable for violations because of his involvement with the company's import practices. There's some extenuating circumstances that caused me to state that it was bad facts leading to bad law. I know that Dyke Yaxley is going to distribute after today's presentation some additional materials, including an article that I've written about that case, and you can learn about that more fully there. Again, I handle a lot of different international trade compliance matters. I would just quickly point you to California. That's essentially foreign law to the rest of us throughout the U.S. because they have their own sets of laws that oftentimes vary with other states and even our federal government. And with that, I will turn it over to Ben.
Hi, Ben, can you hear us? Do you want to, John, while we're just getting Ben, do you want to just say a little bit more about, from a UK perspective, when you have an export coming into the US, what sort of liabilities does the UK company have if they really don't have any presence here?
Well, under this Trek Leather case, and it's a relatively new case, Rob, so we haven't seen exactly how the Department of Justice is going to apply this decision, but it's anyone involved with the U.S. Import could be held liable for the customs penalty. And my view is that it can also include a complicit party, particularly if there is intent to perhaps undervalue goods or misdescribe goods. But if erroneous information is provided by a UK exporter, they may not necessarily be penalized. However, they may become part of the investigation. And I always like to tell clients, you don't want to become part of someone else's investigation. So I think the UK companies need to make sure that their US customers and business partners, distributors, what have you, are complying with the customs regulations so that they do not get embroiled into a CBP investigation.
Ben, can you hear us? For some reason, it looks like we've lost our connection with Ben at the moment. I've got some other. So, John, another thing that we find very often with a lot of our clients when they're coming to the US is that the fact that, as you talked about, a non-resident importer, I have had situations or talked to clients where there is a situation where they don't want to, in a sense, have a presence here in the US. They will use a freight forwarding company here in the US and then potentially can get locked in a little bit with respect to that freight forwarder. And I have had situations where the freight forwarder, in a sense, the cost of using the freight forwarder has become very prohibited. Is what solutions do they have there to try and help from a freight forwarder perspective? We'll just answer this, and it sounds like Ben's on there, but if we can just answer this question, John, and then we'll go to Ben.
Well, a non-resident importer strategy can avoid that scenario where you become beholden to a freight forwarding company or a customs broker here in the States. You can continue to control the goods. there's really not much to it. You need to appoint someone within the jurisdiction where you are importing to be an agent in case there are notices from CBP that are issued, such as a request for information regarding particular shipments. But I think for companies that do not have a U.S. presence but do want to be engaged in imports here, non-resident importer strategy might be more attractive than appointing a essentially stranger and introducing that third party into the transaction.
Thank you, John. Ben, are you there?
Yeah, I'm here. I apologize for that. Sorry. Thanks everyone. My name is Ben Farber. I'm a partner at Phillips Lytle in the Albany office. My practice is a little bit different than John's. I'm a general corporate practitioner. I do a lot of mergers and acquisitions, formation of companies, some securities work, some tax work, some venture capital work. So all sorts of things relating to companies and the participants in it and transactions relating to companies. So today I'm going to talk a little bit about two topics. The first being foreign qualification, and the second one being issues associated with director and officer liability. So foreign qualification first, and we can move from that one slide onto the next one. Foreign qualification is essentially, an approval or a consent that's provided by a state agency. Typically, it's the Department of State in a particular state. Upon application of if the entity wants to do business in that state. So, to frame that discussion, I have a basic hypothetical here on the PowerPoint. Corporation A is incorporated in Delaware, and I understand from Rob, a lot of you either have LLCs or corps, and a lot of them are formed in Delaware, which is a state where a lot of people choose to be formed or incorporated in. So this particular one in this hypothetical, they have 10 employees in their main office in New York, and I'm going to just change the hypothetical slightly from what's reflected on the PowerPoint. They have an independent contractor who's a sales agent in California, as opposed to having an employee that runs a branch office there. So we can go to the next slide. So when a corporation or LLC is formed or incorporated in a particular state, it's automatically qualified to do business in that state. Sometimes a business will simply choose to incorporate in the state where they principally do business. So if they have their main office in New York, it may be the case where they just form the corporation in New York because that's the easiest for them to do. And then it may possibly eliminate the need for them to be qualified in other jurisdictions. Other times, businesses may choose to incorporate or form their entity to establish their business in a particular jurisdiction because, that state is recognized as providing favorable treatment for certain types of businesses or investors through the courts or by statute. So some examples of that, there are things in the United States called real estate investment trusts. These are typically particular types of vehicles for investing in real estate. And a lot of them are formed in the state of Maryland because Maryland had decided to enact some legislation that's specific to this, and so it's favorable for them to form that. That being said, a lot of these entities aren't located or don't have their main office in Maryland. They have them elsewhere. Similarly, a lot of banks and credit card companies incorporate or become chartered in states that don't have usury laws being ones that put limitations on the amount of interest that you can charge, principally because this will allow them, when they have these credit cards that they originate to customers, they don't have a limitation on the interest that can be charged on those cards. And then other businesses like ones that many of you all have incorporated or formed are in Delaware because of its well-developed corporate law and judicial system that's designed to be responsive to corporate law issues. So in each case, while the companies are formed or incorporated in these states, they may not necessarily have a physical presence in that state, albeit with the exception of some states require registered agents, and that would be a limited presence, but not the company itself. The company, so what happens in those situations is the company will, if they have their office or business in another state, they have to be qualified as a foreign company in those states. But for other states that they may operate or do things with, there are questions to be evaluated as far as that's concerned, and that is, I'm sorry, you can you can move the slide from this slide. I apologize. What is the corporation's particular ties and or contacts with that particular state, and are those ties or contacts significant enough to rise to the level of doing business in a particular state? The analysis as to whether a corporation's activity or ties rise to that level. So that's a question under state law. In contrast to John's presentation, which was largely about federal law, which is a law that applies throughout the United States. Each state obviously has its own law, and corporate law or law relating to limited liability companies, that's a state law question typically. In fact, it is universally. And so each state has its own laws that regulate the formation of companies or what constitutes business or doing business in that particular company in that particular state. All right, so if under that state law analysis it's determined that the company's activities in the state rise to the level of doing business, then the company will need to make a filing with that state's Department of State in order to become qualified to do business in that state. So, I guess the question that arises is, so what? What happens if a company that conducts business in a particular state but hasn't obtained authority to do business in that state? What happens to that company? You can go to the next slide here. And in New York, there are fees, penalties, taxes that will be assessed unless the company has been paying taxes in New York all the while, to the extent that it's been operating in New York and doing things there. And additionally, what will happen is the case that the company will not be able to use New York courts or initiate an action in the courts until such time as the company becomes qualified to do business there. Also, to give you a little bit more context, actually, can you go back one slide? I apologize. One more, I think. Yeah, there we go. Okay, sorry about that. To give you some context, in the transactional context, it's often the case where companies have to make representations and contracts that they enter into with other counterparties, and those may be like basic statements about the company, such as this one in italics down here. That the company here it says the company is a corporation duly organized and validly existing and in good standing under the laws of the state of Delaware and has all requisite corporate power and authority to carry on its business, blah, blah, blah. These are just basic statements about the company to make sure that it's paid all of its taxes, it's in good standing with its home jurisdiction, the jurisdiction where it was formed. And then subsequent to that, there's an underline, this is the statement that relates to whether it's qualified in the relevant states where it engages in business apart from its incorporation or formation state. And the impact here is that if they're not qualified in those states, they may have to revise the representation to say, well, we're not qualified in Michigan and we do business there. And maybe that changes the business terms with the counterparty because they're concerned about what potential liability that you might have as a consequence of not registering in Michigan or whatever other state that you may need to. All right, next slide. All right, so doing business. Like I said before, the question of whether a corporation is doing business in a particular state for purposes of determining whether it needs to be qualified in that state, it's a fact-intensive inquiry. It's also a product of those state laws and the guidance provided by the state agency and other regulations and cases that have been handed down in that particular state. So the basic approach is to assemble all of the contacts that the company has with a particular state and look to guidance provided by the state as to whether that constitutes doing business. Some state statutes address the topic and take a different approach, like the one that's featured here. This is the New York Statute, which says, basically they provide a list of things that don't constitute doing business, and these in isolation. So as you can see on this list, to the extent that you're maintaining, defending, or settling a legal action or proceeding, or settling claims in New York, That doesn't constitute doing business or holding meetings of a corporation's directors or shareholders. If the company who's incorporated in Michigan decides they want to have their shareholders meeting in New York and maybe see some shows in Broadway afterwards, that's not going to constitute doing business. Maintaining bank accounts in New York, doesn't rise to the level of doing business in New York. Or and this is more for companies that are more widely held in terms of shares, maintaining offices or agencies for the transfer of a corporation's securities in New York, or maintaining trustees or depositories with respect to a corporation's securities in New York. Those activities don't constitute doing business. And after this presentation, I believe that Rob is going to be circulating a sort of a white paper or survey that we have from a service company that we use that has basically a 50 state survey of what constitutes, or I should say what doesn't constitute business. To have a series of items that are listed and whether those do or do not constitute business in a particular state. And it's sort of set up similar to this New York statute in terms of the guidance under that. All right, the next slide, please. These are other items to consider whether these would trigger doing business or not. So conducting interstate commerce, and when I say that, it's that might be you're located in one state, you're calling somebody in New York to sell them a product, but you don't have any interaction otherwise apart from calling them. You're engaging in commerce over state lines. In many instances, that doesn't rise to the level of doing business in a state if that's your only contact with the state. Employing people in the state, in many instances, in most instances, in fact, that will trigger a requirement to get registered in that state. Selling through independent contractors located in the state. If you recall in the hypothetical that I had in California, having a sales agent there, that doesn't, at least in California, that doesn't constitute doing business, but in other states it may. Again, it's a state-by-state inquiry as far as that's concerned. Owning real or personal property in the state, that varies. Sometimes it constitutes business, sometimes not. Soliciting orders by mail or through other means from customers located in the state, again, that in itself does not typically constitute doing business in the state. Next slide. So this slide is just about like the ministerial task of actually becoming qualified in the state. It's essentially filing a form with Department of State in New York. There's a series of requirements as far as just filling out the form. Those are cites to the state law in New York that, for a New York corporation or an LLC in terms of doing that. Next slide. These are the types of information that you would provide if you were, operating in New York, and what you did rose to the level of doing business in New York. So it would be highlighting or indicating where the company was formed, in many instances here, Delaware, the county in New York in which your office is located. You would provide a certificate of good standing from Delaware, say that you've paid all your taxes in Delaware, and then you would provide an address where you would forward, where if there was any correspondence from Department of State in New York, where that would be forwarded, whether that's an office in New York or somewhere else. Next slide. All right, so that's pretty much everything on foreign qualification. Now I'm going to spend just a couple of minutes talking about officer and director liability. First, a little bit of nomenclature, and this probably is duplicative for most on the call, but I'll go through it anyway. As Rob told me, people on the call are, formed corporations or formed LLCs. In corporations, the relevant characters are directors, officers, and shareholders. Directors are basically guiding the company from a 30,000-foot view and, look at things from the high end, from the macro level, if you will. Officers are people who are tasked with, kind of operating the day-to-day activities of the company. Shareholders are obviously the equity holders in the company. LLCs, a lot more malleable and flexible in terms of the structure, typically with LLCs. So members they are the equity holders in the company, but they can also be the people who are running the company, depending on how the company is set up. Managers are people in certain LLCs where they're exclusively just running the company and also could serve in a similar capacity to directors. And officers are not something that you necessarily have to have with LLCs, but you can. So it's something that you may be, if a particular company wants, they can drafted into their operating agreement to reflect that. Next slide. All right, so when we talk about officer and director liability, just generally, I mean, the liability can stem from a variety of different, places, but I guess, the one that is the primary focal point, or the one that has the biggest, possible liability, I guess I would say. I mean, it could come from customers or vendors or from employees, but the biggest pool, I guess, of potential liability is from shareholders. And so I think the biggest thing to talk about when you talk about liability of shareholders is fiduciary duties. And these are, directors and officers serve in the role of fiduciary to the corporation and to its shareholders. Similarly, managers and members owe fiduciary duties to the limited liability company. These are fiduciary duties, are just obligations for individuals to conduct themselves essentially in a good faith, trustworthy manner in performing the responsibilities associated with their office or position within the corporation or LLC. Next slide. The basic types of fiduciary, there are two. The first one being a duty of care. So the idea is to, directors, officers, and managers are required to exercise that degree of care that ordinary, careful, and prudent people would use in similar circumstances. Generally, courts have interpreted this to require that the fiduciary act rationally in good faith based on reasonable investigation. So, practical application for this, when if a company is evaluating a target that it's looking to acquire and doing due diligence, it's important for officers and directors to, perform its, to investigate things, to make sure that, for example, the intellectual property, that there's intellectual property protection for the products of the company that it's acquiring, that's in place, that there's not any material litigation relative to the company, or if they have, get little bits of information here and there, it's important for them to follow up and make sure that they find out, get to the bottom of that information. Failure to do so might, cause shareholders to bring an action against the directors to say that they breached their duty of care. If the upshot is that the company acquired another company, but they didn't find out about this huge litigation that the target was embroiled in, and now they bought this company and they bought the liability associated with the subsequent judgment, that could result in liability for the officers and directors because they potentially didn't do the due diligence necessary to find out about that before signing the contracts. Next slide. So the next duty is duty of loyalty, and this is that the directors, officers, and managers are obligated to act in good faith in the best interest of the corporation, which includes avoiding self-dealing or usurpation of corporate opportunity. So where this manifests itself primarily is where you may have a board of directors and maybe one director is he's an outside director, an independent director, and runs a separate business, and he wants to engage in business with the company in which he's on the board. And that's what's called an interested transaction because that individual is on both sides of the transaction. So those, there's more scrutiny that's given to those types of transactions, and you want to examine those closer because the question is whether those are really done on an arm's length basis. And one of the ways to kind of validate or ratify those sorts of arrangements is to have the shareholders themselves approve the transaction after the board, potentially when they approve it. But it's incumbent upon the board to make sure that those transactions are done on an arm's length basis, notwithstanding the fact that one of the board members is on, their board as well as the counterparty of the transaction. Next slide. Business judgment rule. So this is just a general presumption that courts have, in terms of evaluating the decisions on the part of, directors and officers that, that they acted on an informed basis in good faith and in the honest belief that the action taken was in the best interest of the corporation. Basically, the idea is that the default rule is that companies don't want to re-examine the decisions that, or I'm sorry, courts don't want to re-examine the decisions that companies make, and it's only, if the shareholder or whoever's bringing the action, is able to go above or prove that, to rebut the presumption, the basic underlying standard that companies were doing whatever they did on an informed basis. That's when it's incumbent upon in a court case for the directors and officers to demonstrate how it was that they fulfilled these duties and made sure that they satisfied the requirements. Next slide. All right, so ways to minimize and address liability. The easiest one is documenting what steps were done in connection with whatever transactions. So these are typically manifested by way of preparing minutes of meetings of the board, reflecting whatever the steps that were taken as far as evaluating a particular transaction or a particular liability or situation, and having that reflected in the minutes. And another way is to rely on advisors. Actually, both in New York law and Delaware law, directors and officers are entitled to rely upon work product that's provided to them by accountants and lawyers and other experts, and take it at face value and assume that whatever they provide them is the truth. So if there were any errors in those products that were provided, the work product that was provided, that's not the director's responsibility. That's obviously the responsibility of the service provider. And so that might be helpful in demonstrating that they satisfied their requirement, notwithstanding the fact that the information that was provided to them may have been faulty through no fault of the director or the officer. Next slide.
Hi, Ben. I was going to say, I think a couple of these issues at the end might be addressed by just a question, and then there's a couple of questions for you as well. You were talking about, in a sense, how to address the liability through the operating agreement for thing. Perhaps you can just maybe give an example of some of the wording you might have in an agreement that would sort of be an example of sort of what sort of wording you're looking at to minimize a liability.
Right, sure, absolutely. So in limited liability companies, they're a little bit more malleable, a little bit more flexible than corporations, and so in certain jurisdictions such as Delaware, it's possible for managers or members to reduce their fiduciary obligations through contractual provisions in the operating agreement. And the way that you do that is a provision that may say this particular member or this particular manager runs another business or engages in other business ventures, and to the extent that they come across these other opportunities, they're not obligated to present them to this particular company, the company that is the subject of the operating agreement. They don't have to give that, they don't have to present that for that company to evaluate, that they can do their own business independently and not have an obligation or a duty of loyalty relative to that company in that regard. And that's respected in certain jurisdictions.
Okay. Thanks very much, Ben. I was going to say, I think that's been very informative and has helped me understand the question that comes up very often is, what activity am I doing in that state that causes me to be carrying on business there, which means I need to register there. So that certainly clarified that question for me, and I'm sure for everybody listening as well. We had a couple of questions come through which are actually being focused on the importing exporting side, which I will ask and then John will comment on. So the first question is, with respect to if you're a non-resident importer, is there a limit in the quantity or value of goods that can be annually imported?
No. Generally, the answer to that's going to be no. There may be certain quotas and other limitations that come into play because of special provisions under the NAFTA, for example, and other U.S. free trade agreements. But generally, no. There is not going to be a limit on either value or quantity that an NRI can import.
Okay. And then we got another question regarding the non-resident importer, which is a very good question, because I think a lot of this is very subjective, most probably is. If you were talking about reasonable care, and the question is where does negligence and liability and reasonable care cross each other to, in the sense that you become negligent? And if that's the case, is if you're in the UK, what are the sort of penalty systems in place that you could be assessed?
Well, CBP, in fact, for that matter, our U.S. Department of Commerce and State Department on the export side tend to view our laws and regulations as having extraterritorial application. And here it's really not even so much that they're reaching out to a UK company for a potential penalty, but that UK company, by virtue of importing as an NRI, has subjected itself to the laws and regulations that CBP enforces. So even though you may be based outside of the U.S., the U.S. authorities will very often pursue penalties against out of jurisdiction, non-U.S. companies. This happens quite frequently, in fact, both again on the import as well as the export side.
So a few more import questions coming in. One that I'll take now is I can answer it from a tax perspective, but then John can answer it from a customs perspective. Is the question is, and I've heard of this before, is very often when you're supposed to, my understanding is you're supposed to import into the US at the fair market value of the product coming in, and from a tax perspective, whatever price that you use on the import documentation is supposed to be the price that you use in the accounts for the tax returns under IRS statute. But the question is if a customer is asking you to put a different value on the shipping paper, then in a sense what you're selling them to, you're not supposed to do that, correct?
Well, if you do decide to do that, you can find yourself receiving subpoenas from U.S. criminal investigators, as is the case that I have right here in Cleveland, that began with a criminal investigation in 2009. There, the Korean exporter provided two sets of invoices, one for customs purposes or shipping purposes, if you will, and that one went to the customs broker, who then created the entry paperwork, submitted to CBP for the shipment, and then a second invoice was sent for payment. The penalty in that case started out at $1.3 million. I've reduced that to half. We're continuing to fight that penalty, but it's pretty clear evidence of double invoicing, a double invoicing scheme. Just to give you an example of the severity of the penalties and the potential exposure, the loss of duties there is $54,000, and we're dealing with a penalty of more than 10 times that amount. So the answer to that is definitely a no.
Okay. Just being very cognizant of people's time and that. We have got a couple of other questions which we won't just answer now, but we will take note of them, and John will be in contact directly with you. But I'd like to thank everybody, especially John and Ben, for their very informative presentations, which I hope you got a lot of benefit from. There are a couple of pieces of information that I will circulate to everybody who's on the call, which I think you will find useful. One on the importing side and one on from Ben's perspective with respect to qualifying to do business in the state. And once again, just to let you know, we have been recording this, and the intention, if technology works, that it will be posted on our website. So if anybody else within the company wants to listen to it, then they'll be able to, and we will send a link or let you know when it's uploaded to the website. And finally, as I mentioned before, we will do another one of these webinars in sort of early summer, so I'm thinking around about May time. And at the moment, tentatively, the topic would be along healthcare, because I think as everybody who's on the line will know that healthcare from the US and the UK is completely different. And we have a lot of questions on that, so I think that would be a very useful topic. So the topic for May time will be based on US healthcare and comparing, contrasting to the UK. So without further ado, I'd just like to thank you all very much for participating, and I would like to wish you a good afternoon and hopefully a good rest of the day. And in the presentation, you'll see that it's just come up on your screen is Ben and John's contact information is on there. So thank you very much indeed, and we will speak to you soon. Bye-bye.